Welcome back to Southern Crime. We have got more information in on the Oxford High School shooting in Oxford, Michigan. Um, we are releasing because of the title, the shooter's name because he has now been charged as an adult. Oakland County prosecutor Karen McDonald announced charges against Crumbley on Wednesday afternoon, and he was arraigned shortly after. Crumbley is charged with 4 counts of first-degree murder, 1 count of terrorism causing death, 7 counts of assault with intent to murder, and 12 counts of possession of a firearm in the commission of a felony. So the 4 counts of first-degree murder, a fourth victim has died. That is for those four. 1 count of terrorism causing death is for all of the children in the school and teachers, etc., that were harmed by this. The 7 counts of assault were for the other 7 victims, and then 12 counts of possession of a firearm and the commission of a felony is one for each person. The 3 students that had died on Tuesday were identified as Tate. I'm not sure how to say his last name. Myrie Meyer, 16 years old. Hannah St. Juliana, she was 14 years old. And Madison Baldwin, 17 years old. A fourth victim died on Wednesday morning. That was 17-year-old Justin Schilling. That brought the death total to 4. I was looking at my list of the victims, and the only 17-year-old male that I had written down from them was one that was said to be in stable condition, shot in the hip. I'm not sure if that is him or not. The other ones I have were 17-year-old females, but that were in critical condition. But when things are first coming out, information is not always accurate. So I am not sure which one of those victims he was, but it doesn't matter. He is no longer with us. McDonald said there is evidence showing that the massacre was not just an impulsive act. She said, I am absolutely sure after reviewing the evidence that it isn't even a close call. It was absolutely premeditated. There is a mountain of digital evidence, videotape, social media, all digital evidence possible, and we have reviewed it. Absolutely, we are confident that we can show it was premeditation. Police on Wednesday also revealed that Crumbley had a meeting, or Crumbley probably, had a meeting with his teachers and parents to address his behavior. That happened about 3 hours before he opened fire in school on Tuesday. There was no record that he had been bullied, as some students have claimed. During his arraignment Wednesday afternoon, prosecutors disclosed that they found a journal in his backpack in which he wrote he wanted to shoot colleagues at the school. I am going to play the entire court proceeding in here. Crumbley was asked if he understood the charges against him. He said, yes, I do. Oakland County Assistant Prosecutor Mark Keast detailed security camera footage of the massacre that he saw before the hearing. He said, we have had the opportunity to view the video, and what is depicted on that video, I don't have the words. He deliberately aimed the gun at students and began firing at students. After students started running, he continued down the hallway, pointing the gun and firing at them, and firing in classrooms and at students who were unable to escape. Judge Nancy Karniak ruled that Crumbley would be held without bond and be transferred from Oakland County Children's Village to Oakland County Jail. There is a lot coming out about his social media. I'm going to have pictures of some of it here. There's also information about his parents. They apparently 15 years ago they lived in the Jacksonville area, Jacksonville, Florida. The dad had a 2005 DUI arrest, a 2004 arrest for a suspended license. Dad was also arrested in 1995 on check fraud. Mom was arrested in 2003 on check fraud and was also arrested during that 2005 DUI when James was arrested. She wrote a letter to Trump, an open letter to Trump on her blog that expressed her thankfulness for his supporting of gun laws, or hmm, 3, 2, 1. His mother wrote an open letter to the president on her blog, and in part, she wrote about thanking the president for his support of the Second Amendment. She also posted a picture right here of the gun that her and her husband had just purchased for their 15-year-old son, which was that Sig Sauer 9mm, and talked about her and her son going target shooting that day. Her son posted pictures on his social media, Ethan Crumbley, talking about how he got his birthday or his Christmas present, and his pictures of the gun. There is another picture of him from social media, or not picture. 3, 2, 1. There's another post from him linked back to his account on somebody else's post, a bigger channel, and he wrote, "This is the gun I am going to use," and that picture's right here. So, yeah, I am all for the Second Amendment. I believe that people should be able to have guns. And I said before, I have a gun here at my house. It is kept secured. My son is not going to be able to take it and go do stuff like this. My son, who is also 15 years old. Um, and I would hope that if I thought that he was the slightest bit capable of it, that I would be seeking help for him anyway. I am a strong proponent of therapy and counseling and talking to somebody and all of that. So, that's just how I feel. Um, I just, oh, when you hear about these school shootings and you hear that it is a child that took his parents' gun, broke into the gun safe and took his parents' gun, you're like, oh, okay, I can see that. When you hear that the parents purchased this gun for him on Friday, on November 26th, and he turned around on December 1st and shot up his school. And there are 4 victims that have died, and then these other 7 victims with serious injuries. And then all of those children in that school that can't eat right now, that can't sleep right now, that are having nightmares. It's sickening. It's just sickening. So I am going to come down here to, I'm going to, I'm going to play this one first. This one is a home video from when he was, I don't know, cute.
Hello everybody, welcome back to my channel, Ethan. So today, actually, um, so if you haven't seen the about my ferret video, please see it. Well, I'm not forcing you to see it, but if you do want to see it, see it. So basically about that video, how I said, I will make a Nazi Zombies video that night. I couldn't because basically we watched the movie way too late and it was like too late to record, so basically I couldn't do that. And then last night I couldn't make a Nazi Zombies video because I had to go to bed early because I had to go to some ski patrol, whatever hidden stuff is. This is weird. So yeah, I had to go to that, and I can't, and well, I kind of can't really make a video right now because I'm making this video, and I also got school tomorrow, and I'm pretty sure my Nazi Zombies video will take a little bit too much time. So I decided to make a little video just of what I was talking about. Um, also, I will be making hopefully a Nazi Zombies video at least maybe next week or not. You guys really seem to like it, so I'm very happy. Um, so yeah, and I also I hopefully I have Anthony come over to my house soon, cause here's a secret. He doesn't know how to ride scooters, and I'm going to probably do maybe a little vlog of him probably riding a scooter, and yeah, hopefully he falls. Well, I don't want him to fall and get hurt, but fall where it's funny, just for laughs. So yeah, I was just making a quick video about that. I also made another video that I just uploaded earlier. If you haven't seen that, go see that. Um, I will be making at least one or two videos a day since I got school now. Um, I have also changed my channel name. So basically now instead of Santa Finder, I accidentally spelled the Finder wrong. I still had the Santa Finder, but I spelled the Finder right and then put an Ethan at the end because my name's Ethan. I'm Santa Finder. So if you're looking for my channel, go to Santa Finder Ethan because that's where my channel's going to be. It's not a new channel. It's the exact same channel. Also, I might want to talk about the future. Um, so I think about like maybe making another channel, maybe, but it'll probably take a little while. Christmas is coming up, and I'm asking probably for maybe a metal detector. I haven't asked for that yet, but I'm probably going to ask for that, so I might start a metal detector channel. So yeah, you might see that coming soon, or probably not soon, but whatever. Um, yeah, it's basically it. This video. Sorry, it's so short. I don't have much time right there. So yeah. Sorry, this is short. I was just telling you.
So there is that. Like I said, that was quite a while ago when he was young, or like middle school is what everybody had said about that one. Now let's go to court, y'all. This is court. Here we go.
Okay, I'm calling Crumbley 216611. And Mr. Kosak, your appearance, or actually Mr. Keys first, your appearance.
Thank you, Judge. Mark Keys on behalf of people.
Mr.
Once again,
Kosak.
I'm Scott Kozak on behalf of Mr. Crumbley.
Ms. Hatton.
Sorry. Yes, Your Honor. Nadine Hatton. I was formally appointed to Mr. Ethan Crumbley as his juvenile attorney.
Thank you. And Mr. Crumbley, could you state your full name for us, please?
Ethan Robert Crumbley.
Thank you. Mr. Crumbley, at any time you do not hear or understand myself or any of the parties to the proceeding, will you please let the court know?
Yes.
Mr. Kozak, have you had ample time to talk to your client as well as with Ms. Hatton, along with Mr. Crumbley's parents, to proceed with an arraignment?
Yes, Your Honor. I appreciate Ms. Hatton's presence as well as Mr. Crumbley's parents. I appreciate the court's time in allowing us to get acquainted. Mr. Crumbley was present for the swear to. He does for purposes of arraignment, if the court wants me to proceed, I can at this point in time.
Yes, okay. So then I'm going to, Mr. Crumbley, I'm going to advise you of your rights and the charges against you. Again, if at any time you do not hear or understand anything, will you please let the court know?
Yes.
You do have a right to remain silent. Anything you say can and will be used against you in a court of law. Do you understand that right, sir?
Yes, I do.
All right. Count one does indicate that you did that on or about November 30th, 2021. Ethan Robert Crumbley did knowingly, willfully, deliberately, and with premeditation commit murder first degree, a violent a felony that the defendant knew or had reason to know was dangerous to human life while intending to intimidate or coerce a civilian population, to wit, the Oxford High School community, and cause the death of Madison Baldwin, Tate Meyer, Hannah St. Juliana, and Justin Schilling, contrary to MCL 750.543F. This is a felony punishable by life without parole or a minimum of 25 to 40 years and a maximum sentence of at least 60 years, with reimbursements for government expenses incurred for this violation. This is otherwise known as terrorism causing death. Count 2 indicates that on that same date and time, November 30th, 2021, Ethan Robert Crumbley did deliberately with the intent to kill and with premeditation kill and murder one Madison Baldwin, contrary to MCL 750.316. This is a felony that is punishable by life without parole or a minimum sentence of 25 to 40 years and a maximum sentence of at least 60 years. This is otherwise known as homicide or murder in the first degree, premeditated, being a juvenile defendant. Count 3 alleges that on November 30th, 2021, Ethan Robert Crumbley did deliberately with the intent to kill and with premeditation kill and murder one Tate Meyer, contrary to MCL 750.316. This is a felony punishable by life without parole or a minimum sentence of 25 to 40 years and a maximum sentence of at least 60 years, also known as homicide, murder first degree, premeditated by a juvenile defendant. Count 4 alleges that on November 30th, 2021, and again, all of these, I'm sorry, are in the Township of Oxford. I did indicate that and will continue to indicate that Ethan Robert Crumbley did deliberately with the intent to kill and with premeditation kill and murder one Hannah St. Juliana, contrary to MCL 750.316, felony, life without parole for a minimum sentence of 25 to 40 years and a maximum sentence of at least 60 years. And this is in violation of MCL 750 again, .316. This is homicide, murder first degree, premeditated by a juvenile defendant. Count 5 alleges that on November 30th, Ethan Robert Crumbley did in the Township of Oxford deliberately with the intent to kill with premeditation, kill and murder Justin Schilling, contrary to MCL 750.316, a felony life without parole or a minimum sentence of 25 to 40 years and a maximum sentence of at least 60 years. This is called homicide, murder first degree, premeditated by a juvenile defendant. Count 6 alleges that on November 30th, 2021, Ethan Robert Crumbley did in Oxford Township make an assault on Phoebe Author with intent to commit the crime of murder, contrary to MCL 750.83. This is a felony punishable by up to life or any number of years, DNA to be taken upon arrest. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. This is also known as assault with intent to murder. Count 7 indicates that on November 30th, 2021, Ethan Robert Crumbley, while in the Township of Oxford, did make an assault upon John Asciutto with intent to commit the crime of murder, contrary to MCL 750.83. This is a felony punishable by life or any number of years, DNA to be taken upon arrest. This is also known as assault with intent to commit murder. Count 8 indicates that on November 30th, 2021, Ethan Robert Crumbley did in Oxford Township make an assault upon Molly Darnell with the intent to commit the crime of murder, contrary to MCL 750.83. This is a felony punishable by life for any number of years, and DNA to be taken upon arrest, also known as assault with intent to murder. Count 9 alleges that on November 30th, 2021, Ethan Robert Crumbley, while in the Township of Oxford, did make an assault upon Riley Franz with intent to commit the crime of murder, contrary to MCL 750.83. This is a felony punishable by up to life or any number of years, DNA to be taken upon arrest. This is called assault with intent to murder. Count 10 alleges that on November 30th, 2021, Ethan Robert Crumbley, while in Oxford Township, did make an assault upon Elijah Mueller with intent to commit the crime of murder, contrary to MCL 750.83, a felony, punishable by life or any number of years, DNA to be taken upon arrest. Also, again, assault with intent to murder. Count 11 alleges that on November 30th, 2021, Ethan Robert Crumbley, while in Oxford Township, did make an assault upon Kylie Assange with the intent to commit the crime of murder, contrary to MCL 750.83. This is a felony, punishable by life for any number of years. DNA to be taken upon arrest. Count 12 indicates that on November 30th, 2021, Ethan Robert Crumbley, while in Oxford Township, did make an assault upon Aiden Watson with intent to commit the crime of murder, contrary to MCL 750.83, a felony punishable by life or any number of years, and DNA to be taken upon arrest. This is also called assault with intent to murder. There are now 12 counts of possession of a firearm in the commission of a felony. Counts 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23, and 24. They do allege that on November 30th, 2021, in Oxford Township, Ethan Robert Crumbley did carry or have in possession a firearm, to wit, a pistol, at the time he committed or attempted to commit a felony, to wit, terrorism causing death. Also, murder in the first degree for count 14, murder in the first degree for count 15, murder in the first degree for count 16, murder in the first degree for count 17, assault with intent to commit murder for count 18, assault with intent to commit murder for count 19, assault with intent to commit murder for count 20, assault with intent to commit murder for count 21, assault with intent to commit murder for count 22, assault with intent to commit murder count 23, and assault with intent to commit murder count 24. This is contrary to the laws in the state, specifically MCL 750.227B. This is a felony punishable by up to 2 years consecutively with and preceding any term of imprisonment imposed for the felony or attempted felony of conviction. This is called possession of a firearm in the commission of a felony. Sir, do you understand all the charges against you?
Yes, I do.
Again, you have a right to remain silent. Anything you say can and will be used against you in a court of law. Do you understand your right to remain silent?
Yes.
You also have, of course, your right to an attorney, and Mr. Kozak and Ms. Hatton have been with you, and that right will continue throughout all legal proceedings. And as it relates to anything further, we do need to set a bond. As it relates to bond, I will first let actually, we do have pretrial services here to make a recommendation as to bond, and then we will let each attorney speak as it relates to that. So if the individual from pretrial services can come forward, state your full name and spell it for a recorder.
I'm sorry, Judge, just before we do that, I just want to make sure it's clear that my client is standing mute. We're asking the court to enter a not guilty plea.
Oh, I'm sorry. Yes, I will enter a plea of not guilty on his behalf, and we will set this for bond. Thank you, Mr. Kozak.
Darla Finley, Pretrial Services, DARLAFINLEY. The defendant was unable to be interviewed due to his location at the Children's Village, therefore that we have limited information. We do know that he's 15 years old, resident of Oxford. He's a sophomore at Oxford High School. He has no prior juvenile record, no noted police contacts in Clemens. Given the serious nature of the matter, there's no conditions or combinations of conditions which will assure the defendant's appearance in court or safety to the community at large. Therefore, we recommend that bond be denied.
Thank you from Pretrial Services. Mr. Keast, anything you'd like to say?
I would, Judge, thank you. Because the defendant is a juvenile charged as an adult, this court must look at Michigan Court Rule 6.909, subparagraph 2. That court rule states that regarding detention without bail, if the proof is evident or if the presumption is great that the juvenile committed the offense, the magistrate or the court may deny bail, subparagraph A, to a juvenile charged with first-degree murder. Judge, in this case, I am asking this court to deny bail as pretrial supervision has indicated. As a offer of proof, I think it's appropriate for this court to have a brief chronology of what happened on November the 30th, 2021. As you heard during the swear to, Judge, Oxford High School is equipped with surveillance video. We've had the opportunity to review that surveillance video just this morning. And what's depicted on that video, honestly, Judge, I don't have the words to describe how horrific that happened on November the 30th. It depicted just before 12:51 p.m., this defendant entering a bathroom with a backpack. A minute or two later, he exited the same bathroom without the backpack, but with a gun in hand. At that point, he methodically and deliberately walked down the hallway, aiming the firearm at students and firing. Right outside the bathroom, he began firing, Judge. After children started running away from the defendant, he continued down the hallway, again at a deliberate and methodical pace, pointing and aiming inside classrooms and at students who hadn't had the opportunity to escape. This continued on for approximately 5 minutes. The defendant went to another bathroom. As deputies arrived, he set the firearm down and he surrendered. Judge, a preliminary review of the defendant's social media accounts, his cell phone, as well as other document evidence recovered on scene, showed that this defendant planned this shooting. He deliberately brought the handgun that day with the intent to murder as many students as he could. Judge, I believe no bond is appropriate. And again, like I stated, at the appropriate time, I'd like to make a motion to transfer this defendant from Children's Village to the Oakland County Jail.
Thank you. Mr. Kosak?
Your Honor, understanding the extreme nature of this case and understanding the circumstances at hand, and having spoken to Mr. Crumbley as well as his parents, I'm going to leave the setting of the bond and the discretion of the court.
Thank you. Anything further from Ms. Hatton?
Nothing further, Your Honor. I leave in the discretion of the court.
Thank you. And I'm assuming you don't want your client to speak.
That's correct, Your Honor, on both Mr. Kozak and my behalf.
Thank you. I do believe, based upon all the information that's been provided to date, that a no bond, a denial of bond is appropriate pursuant to court rule, and I will order no bond on this case. Of course, your client does have a right to a preliminary exam within the statutory 21 time period, as well as a probable cause conference. I don't know if the court should have set something, or have we set something? Do we know? Oh, it's on the front of the file? Okay. All right. A probable cause conference will be set on December 13th at 1:15 in front of myself. And then an exam the following week on December 20th at 1:15, again in front of myself. Anything further from the people or the defense?
Thank you, Judge. I do have a motion for the court. The defendant is currently housed in Children's Village, if I may.
Yes.
Thank you, Judge. Under the same court rule, MCR 6.909, subparagraph B regarding place of confinement. Subparagraph 2. On motion of a prosecuting attorney or a superintendent of a juvenile facility in which the juvenile is detained, the magistrate or court may order the juvenile confined in a jail or similar facility designed and used to incarcerate adult prisoners upon a showing that the juvenile's habits or conduct are considered a menace to other juveniles. Judge, in this case, I can't think of a more appropriate set of circumstances for a transfer from Oakland County Children's Village to the Oakland County Jail. Now, this court must also look at the statute, and that's MCL 764.27A. I spoke with Lieutenant Tim Willis, who is the officer in charge, into the square two this afternoon. He has confirmed that the Oakland County Jail can house this defendant in a location out of sight and sound from adults, and that's the standard in the statute, Judge. The Oakland County Jail is better equipped to handle this situation. They have done so in the past. They have done so in conformance with the statute. It is a more secure location, and I would ask that this court find that this defendant's conduct is a menace to juveniles by evidence of the simple fact that he targeted juveniles in this offense. Count one is a charge of terrorism via murder, Judge, and the evidence that will come out of the preliminary examination and the subsequent trial will show that this was a planned event, it was methodical in its operation, and it was done so to terrorize and intimidate others in the community, Judge. I do believe the Oakland County Jail is the appropriate location to house this defendant. Thank you.
Thank you. As it relates to that issue, Mr. Kosak and Ms. Hatton.
Thank you, Your Honor. All due respect to Mr. Keast, Your Honor, I want to remind the court, and I know the court doesn't need reminding, that these are allegations. He has not been found guilty of these issues or these charges as of yet. And I'm asking the court to, I'm objecting to the transfer at this point in time. I think the Children's Village is more than capable of monitoring him and maintaining the safety of the other residents of that facility. And I think at this point, Judge, if the court's going to consider this motion, I would ask the court to perhaps hold the ruling in abeyance until after the preliminary examination, at which point the court will have had a chance to have taken sworn and heard sworn testimony regarding these incidents.
Regarding the
Regarding
issue
the
itself, or
incident
regarding the fact that he shouldn't be moved?
Regarding the incidents itself, Your Honor, and because I believe that's what the prosecution is using as a reason for the transfer in and of itself. That's evidence of the need to transfer.
Thank you. Ms. Hatton?
Your Honor, just very briefly, this court has already found that the proof is evident under 6.909. And I know this is a preliminary showing. Obviously, defense has not had the opportunity to review discovery, neither has this court. However, it is alleged in these 24 counts that this defendant didn't commit first-degree murder upon anybody, but he targeted other juveniles. And I believe that 6.909 subparagraph B is written specifically for a situation such as this. The Oakland County Jail is the appropriate location for this individual, Judge. It is, like I said, well equipped for this. They have the ability to keep this defendant separate from both sight and sound of other adults. This is appropriate in these circumstances, Judge.
Ms. Hatton, anything further?
Aaron, I concur in Mr. Kozak's argument. I will advise the court that as Mr. Ethan Crumbley's juvenile attorney, I did have an opportunity to speak again with Mr. Ethan Crumbley at the juvenile facility, Children's Village, as well as the individuals who are supervising Mr. Crumbley, Ethan Crumbley at Children's Village. It's been reported to me, Your Honor, as an officer of the court, that Ethan has been cooperative. He is on suicide prevention there at Children's Village. He's not in general population. He's secluded and he's receiving one-on-one supervision. I would ask the court, based on that information, and that he is cloaked in the veil of innocence unless proven guilty, that he remain at Children's Village until after the preliminary examination. Given that Children's Village is suitable and able to maintain the safety of the other children at Children's Village, I believe it is appropriate at this time that Ethan remain at his current placement with the current conditions and supervisions in place until the preliminary exam, which is in a matter of days, December 20th, 2021, as this court has set.
Thank you. I'm going to ask to hear from Lieutenant Willis regarding safety issues and what is considered. If you want to come up to the podium, Lieutenant, and state your full name for us, please.
Lieutenant Tim Willis.
And Lieutenant Willis, I had heard from Mr. Keast that you thought it was appropriate for him to be moved to the adult facility. Is that correct?
Yes, Your Honor.
Okay, could you explain to me why you feel that way?
Well,
I mean, besides the obvious of what is alleged to occur.
right, so obviously I agree with Mr. Keys about the incidents that I've witnessed for, via the video and all that stuff. But also the sheriff's office in the past had several juveniles. I've actually worked in that jail and know for a fact that how, I just have all the confidence in the world in my team, the sheriff deputies in the jail to secure him and keep him completely sequestered.
So how does that work? Explain what would happen to him and how he would, what the his
Yeah.
placement would be.
Yes, Your Honor. We have several jail cells in and around, but typically we have where he would go, where he would be placed is a clinic area, and it's completely secluded off from the rest of, it's the only thing, there's a glass front door, but everything else is bricked in. So it's completely private, completely back and away, and a deputy monitors, and
So
so.
we had no contact whatsoever with any adult inmates, is that correct?
That is correct, Your Honor.
Okay, and he would be in that facility by himself?
Correct, and there would be no, again, the only adults he would hear would be the deputies working there,
All right.
but no inmates.
Thank
Not
you.
seeing them work here though.
Thank you.
Yes, Your Honor.
Under the circumstances and based upon the nature of this offense, still, of course, understanding that the defendant has a right to be presumed innocent until proven guilty beyond a reasonable doubt, I'm going to certainly err on the side of caution. I think it is within the court rules to do so. And I would agree with Mr. Keese. This is the perfect example of a case that should be done to protect other juveniles. So I will have him moved to that facility, as it has been indicated that he will be in isolation and will not be in contact with any other adult inmates, but only that of sheriff's deputies. Anything further?
Not from the people, Judge, thank you.
Your Honor, the only other matter would be making sure that he has counsel at the date of the probable cause conference. I'm not sure if the court has paperwork already prepared on his behalf, but he will need court-appointed counsel at that point in time.
So I'm not sure who that is obviously is done by circuit court. Do we know what's going on in that regard?
He will just need to fill out the court-appointed attorney request, Judge, and they will get.
Okay, so, all right, Mr. Crumbley, we want to make sure that you have counsel at each and every future court date. So we're going to make sure you have that paperwork today to fill out so that you will have an attorney present at your probable cause conference, your preliminary exam, and all future proceedings. Do you have any questions about filling out that court-appointed attorney form?
No, Your Honor.
Okay, thank you, Mr. Kosak. Okay, if there's nothing further, we are in recess. Thank you.
Thank you, Judge.
Okay, so there was the entire
There have been serious.
there is the entire video from that. Oh, here. So there was the entire video of his court appearance today. There's a couple more that I am going to show you.
Till now, only 7 Action News has confirmed there were 2 meetings between school officials and the 15-year-old sophomore charged, Ethan Crumbley. One meeting was on Monday, the second on Tuesday morning, and that one involved Crumbley's parents. That was just hours before 10 students and a teacher were shot, 4 students killed. 7 Action News reporter Jim Kirchner talked exclusively with the Oakland County Sheriff about the investigation and has more on these critical moments. Jim?
Carolyn, so many people inside Oxford High School saying they can't sleep. They want answers. They're not getting them. They are relying on us, and the sheriff agreed to talk with us. He says school officials are cooperating fully now. He says he knows who were inside those 2 critical meetings. He knows what was discussed. His liaison officer inside that high school was not included. Were there warning signs that were made aware to school officials that perhaps someone missed?
Obviously, this is all part of the investigation and is part of our evidence and our process now because we've transferred over into the prosecution side. So I can't get into specific evidentiary issues because we certainly don't want to jeopardize prosecution. In hindsight, where we all have 20/20 vision, do I wish we would have been drawn into this information prior? Absolutely.
The sheriff has revealed school surveillance video shows Ethan Crumbley walked into a bathroom with a backpack, came out without it, and opened fire with a 9mm semi-automatic handgun. After that meeting that morning, he was returned to class. Is that your understanding?
Correct.
And anybody search a backpack, which theoretically he could have been carrying the gun at that time, correct?
To my knowledge, no.
But he could have had the gun with him this whole time.
Could have.
Yesterday, we saw Crumbley's parents, Jennifer and James, on the Zoom during their son's arraignment in court. They told their son not to cooperate after he was arrested, and he hasn't. And they have not cooperated. They were in that meeting at the school with their son Tuesday morning. Were the parents given any instructions on how to proceed after that meeting?
I can't get into what was said or done in that meeting for evidentiary reasons, but there was discussions.
The sheriff has been consistently saying his team had no warning signs prior to the shooting, including from school officials. You've told the community, if you see something, say something. Did school officials do that?
Well, again, in hindsight, now that we know all that we know, certainly we wish we would have been brought into that meeting or informed of that meeting.
Now, the sheriff says he has told school officials they are free to discuss this while he can't, and the people inside the school say they have a lot more questions, including the critical one: who made the decision to allow Ethan Crumbley to return back to class just a couple of hours before this terrible tragedy? We're going to stay on this, of course. Reporting live in Pontiac, Jim Kurtz, 7 Action News.
So much more to learn. Thank you, as always, Jim. There have been serious questions about.
Okay.
Okay, so there is that, and then there's one more video. Let's see, Ethan Crumbley parents on Zoom. They have said that the parents may be charged. They, for okay, so the parents there's a possibility that the parents may be charged. That is being investigated. I think that it is more so because they purchased the gun for him. He obviously had easy access to it. You know, there's a reason that we have age limits for handguns. That's all I'm saying. And like I said, I completely support the Second Amendment. We are gun owners, but gotta keep them away from the kids, y'all. So that is all that I've got on this one. I'm sure that there is going to be more coming out of this. I'm praying that it is not any more deaths. I hope that all of them do okay. We will see you all later. Thank you. Bye, y'all.